Is it on?
Hi, everyone, and welcome to the IP webinar. We'll be discussing the IP Bill 2020. My name is Liz Lendro. I'm one of your moderators. I'm an intellectual property lawyer and an advocate of the High Court of Kenya, and I run an entity called My IP Legal Studio. On to you, Alu.
Thank you, Liz. Hi, everyone. I am Eileen Aluso Ingati. I am a member of the LSK Council and a partner at Kazi Advocates LLP. I practice intellectual property law and technology law, and I'm happy to have you guys here.
Okay, so I think without further ado, we'll introduce our panelists in order of seniority.
All right, so Maria, are you here? Maria is not here. All right, so we'll move on to David Murithi. David, karibu sana. David is a finance director at Six Arms Limited and the CEO of Creative Enterprise Center. I'll give you a minute to say something small to the audience.
I'll also add that I was a former director on the Kenya Copyright Board for 6 years and a creative enthusiast. First of all, thank you for actually holding this webinar, because I think it's the first of many conversations that will take place regarding the proposed bill, which admittedly is at its most initial stages. And I think this discussion has to be tempered by that fact. And it's the beginning of a good panel beating that's needed to put it in the right form that can be discussed with the wider public in future. So yeah, thank you very much.
Karibu sana.
Karibu. Our next panelist is Ms. Carol Theory. She's a seasoned IP lawyer and practices under Mudhoni Advocates. Karibu sana, Carol. Please say one or two things.
Hi, Liz. Thank you so much for inviting me to this panel. To be able to have the chance to look at the IP Act or the bill at this point in time is a good start for IP practitioners. There's a lot of things that we have been dealing with that can be, enhanced in this bill. Admittedly, it's a large bill. I don't think we're going to be able to get through talking about most of the issues here today, but it's a good start. With my experience from various jurisdictions that I've practiced in, I hope to be able to add some insight into this panel and hopefully future discussions.
Okay. Our next panelist, Mr. Nonini, the chairman of Creative Society of Kenya, and of course, a renowned hip hop artist. Salimia watu.
Niaje watu, hope mko poa, hope everybody's well. Ushani introduce hata, see, I don't think na nilikuja introduce even more, but maybe I can say yes, like what has been said. Mimi ni msanii wa kizazi kipya, pioneer of genge music in Kenya. I'm a former chairman of Performers Rights Society of Kenya and director, but currently I'm the chairman of Creative Society of Kenya, which is the umbrella body for the creative industry, the major creative industries in Kenya. Antony.
All right, then we have Mr. Bernard Maweo, who is the chairman of the Intellectual Property Owners Association and the chairman of the Music Publishers Association of Kenya. Karibu sana, Bernard.
Thank you very much. Yeah, I'm here today as a rights owner. By profession, I'm a software developer, but I have a lot of interest in the creative industry. So I own music production companies, I think 1 or 2. I'm also involved in music publishing. So my organization, Music Publishers Association, is a member of the International Confederation of Music Publishers worldwide, which means we represent the interests of music publishers here in Kenya and across the globe. This bill is of a lot of interest to me and our members because it will touch on the rights. We like to say intellectual property is the currency of the creative industry. So it's an important bill that we want to make sure that the right contents go into the bill. Thank you.
All right, I see Maria is now with us. Is she? Yes, karibu sana Maria. Ms. Maria Mbenekar is a member of the Council of the Commonwealth Lawyers Association and a partner at KKM Advocates. You can have a word with us. Maria, we cannot hear you. I don't know what's happening on your end.
Can you hear me now?
Yes, we can.
Okay, thanks for the invite. I was having a bit of technical issues. The video on my laptop is not working, so I've connected through my phone. Yeah, so I'm happy to be here. This is a very timely discussion. The reason why we are having this discussion today is because we had a sector webinar last week. Bernard, thanks for that invite. And it became apparent to me and others like Liz who had attended that particular webinar that this is a webinar that we were able to see that the creatives as well as the lawyers were having a lot of issues with the bill. And we decided to come together so that we can get as many advocates on board to look at it. As those are the ones who are practicing in the IP area, as well as the creatives who also happen to be our clients. And having spent a couple of days looking at it, it's quite frustrating to see that, well, it's a bang up job in terms of copy pastes. And a lot of the amendments to the various acts have not been incorporated in this bill. It's still very raw in my view. It needs a lot of work, but it would be interesting now for us to participate in it because it will end up in Parliament, and we are better off actually informing the inputs to this particular bill before it gets to Bunge, and even during the public participation, we'll have refined it quite a bit. So I'll be talking about the dispute resolution aspect of this bill, and let's see how far we can go. I can see we have about 50 participants on board. Sorry, 234 participants. So I expect that we'll have a lot of input from those who've been able to go through the bill. Thank you very much for having me.
Thank you. So for those who are joining us, a little background on this intellectual property bill. In 2013, the president had put together a task force to discuss the merger between the Kenya Industrial Property Institute, the Kenya Copyright Board, and the Anti-Counterfeit Authority. Now, I think one of the biggest questions we should be asking, we are asking ourselves is, have we been sufficiently consulted as members of the public, as lawyers? Are we ready for it? Is it necessary? I think that's where we should ideally start. So I'll start with you, David, since you've been a former director at Kekobo and having insight as a director in terms of how even the Copyright Board has been operating. What are your thoughts? Have we been, consulted enough? Do you think it's necessary? Please share some of your thoughts.
Well, unmute myself. Well, thank you, Liz. The merger talk actually began while I was on the board, when our then executive director, Maricela, met with the other two boards, CEOs, and discussed the initial draft of the document. And a lot of it at the time centered around basically the setup, what it would look like, et cetera, et cetera. Then it went quiet for a while. The submissions were made, went quiet. Then, last year there was a resurgence of interest in this merger. And as we've seen more recently in an article published, there's a looming new trade agreement with the Americans. And one of the things that has been stressed is the issue around intellectual property, strengthening of intellectual property laws. What's interesting, I think my view around whether or not there's been enough consultation is that there hasn't been actually. And it's very visible in the document that's in front of us. 3 or 4 laws and acts have been bunched together, and I don't think there's been much detailed thought about how this is actually going to be administered. So I hope that's one of the things we'll be able to disseminate and analyze during this webinar.
Yeah, and just before we move on to the next panelist, for you, David, in your view, is it necessary for this merger, in your thoughts?
There are 2 ways of looking at it. I can look at it both as a creator myself. I can look at it as a creator and say, as a creator, I think if it were done properly, it would be possibly easier because you're able to, one-stop shop. There's usually a lot of confusion between all the 3 bodies. When a creator wants to protect their, intellectual property, where do they go? There's a lot of confusion around that. However, from a practical point of view, I strongly feel that as proposed in this bill or proposed bill, copyright will be diminished. Its role will be really heavily diminished. For example, when you look at the merger with anti-counterfeit, who usually demand a fee before enforcement under the Copyright Act and under Kekobo, usually that doesn't take place. So there'll be a little confusion, especially for the creators. Creators in this country are not very well off. When you look at, and I'll speak this to the lawyers, I know there's leaning towards patents and trademarks because, there's more money there. You've got organizations like CAM and KEPSA really pushing that end of things. But creators normally are slightly hand to mouth in comparison, yet it said they contribute about 5.6% to GDP. So I think there's a bit of an anomaly there. I'd like to explore that a little further.
So you feel that we need to be, we need to be more clear in terms of streamlining the operations and merging the rules and all that?
Totally, I couldn't agree more.
Okay. So we would move on to Bennett and hear your views on this bill, and mainly because we are informed that you're an Intellectual Property Owners Association chairman. So what exactly are your views on this, and what do you feel about it all?
Thank you very much. I'll agree with David that the copyright aspect would need to be highlighted more in this merger, because the other two appear, out of the three, appear to be well, let me say well funded in terms of the role that they play. Copyright seems to be getting less attention compared to patents and trademarks and the fight against counterfeiting. So this bill needs to not just be a lift of the other three acts into one document, but I think we need to pay attention to exactly how things will happen when the three acts are put together, and also ensure that we put in focus the fact that and allow me to speak a bit about music. Music is a very unique product, if I may say. While in patenting, people sit and think through the production of a product or a service. A song you could go and have a shower and sing, and somebody hears you sing very well and decides they'll take you to a studio and produce a very, very, very nice song that becomes a big hit, but you really don't understand the rights that you hold around that song. So the law needs to be more, the law needs to protect you more naturally, to let you take a bit less effort to ensure that you're protected. And even when you compare, yesterday I read a piece on Daily Nation that some young man was charged with distributing the Nation e-newspaper. And when I was reading that piece, I kept thinking how many times I see people forward songs on WhatsApp to each other. And I kept wondering, but why isn't this same action being taken about music and videos and movies that are being shared online? So I think there's need to balance. David, I agree with you on that one. Whether it's necessary to merge the three or into one, I think if the necessary steps are taken, then it would be okay to merge and have one-stop shop. But we must be careful that the merger doesn't end up swallowing some of the benefits that the individual organizations are providing the members at the moment. Yeah.
Okay, I think we'll ask you, Nonini, as well, to share your thoughts before we move to the lawyers.
Nonini, we cannot hear you.
Can you hear me?
Yes, we can.
Okay. Whether it's a good idea or not to merge the three bodies, I wouldn't comment on that. What I can say is, as creative or as musicians, first of all, they don't even understand the structures of IP. So a lot of more workshops and education needs to go out to the industry. Most of the upcoming artists, even the artists who are there currently, the mainstream artists, some of them don't understand IP ni nini. Ukiongea IP, wanafikiria ni ile movie ya IP Man, who was the trainer of Bruce Lee. They don't understand it's intellectual property. So a lot of workshops need to happen for people first to understand actually what IP is before we even break down the structures. Ukianza kwa confused, kuna three bodies, Kipi, Kekobo, anti-counterfeit merging into one, it's confusion already, you get. So more workshops and education needs to be done. But whether it's good for the three to be merged into one, I think if it's like the way Bernard and David have explained, if the structures and the procedure is followed well, it's gonna be a good thing.
Okay.
Okay. So allow me now to go to Maria and Carol. And we're answering the same question, but now with a more of a legal twist or center, right? So Nonini has touched to the fact that Kenyans are having a problem to differentiate between copyright, patents. For them, IP has been IP or IP has been patents, right? So in your thoughts with this IP bill, would it have been easier for us to have maybe an intellectual property offices coordination bill or something, as opposed to an IP bill where we are merging all these acts? And as you're answering that, have you seen any jurisdictions that have merged all these acts into one particular document? Yeah, so I'll start with you, Maria.
Voice.
Maria? Okay, Carol, please start.
Thanks, Liz. Yes, so I think definitely on the right track, talking about, an IP officers coordination bill, that might have been the best way to go, especially because there is definitely confusion with regards to IP and what body represents what. Many times I've had clients come up to me and say they want a trademark, whereas actually it's got an artistic work, or they say they want a patent and it actually turns out to be a trademark that they want. So I think definitely the merger of the offices in terms of just having a one-stop shop for IP rights holders would be great, because also there would be a help desk which would kind of just give them a bit of an overview and direct them in the right direction, rather than either having to go to Upper Hill and then you're told, go to Wetlands, which is quite frustrating. In terms of other jurisdictions, so this is not a new phenomenon in terms of all the IP offices being housed in one body. I was recently in Uganda. They have a similar situation there, but their work, the level of the amount of work that they have, the amount of people actually registering their IP is very, very limited. So actually you'll find there's about maybe 6 or 7 examiners who examine the different types of IP, whereas in Kenya we've got, whole buildings, huge departments where that's being done. Nigeria has an IP bill, or I'm not sure if it's an act, and it has it's similar to what we've got here. So they've merged all the IP laws into one, book, but not into one law, and but the offices remain separate. So in the sense that I think as in terms of we're looking at how many companies, persons register IP, Nigeria is top, South Africa is top, and then Kenya, definitely comes in the top 10. So I think if we're looking at how exactly this would work, we need to look at jurisdictions where they have the same level of IP work or IP registration. And you find that in those jurisdictions, they still have separate offices, they still have separate laws that guide, with the exception of Nigeria where they have it in one law. But they still haven't, each individual IP law is almost treated as a separate law. When they look at the bill, they're looking at that different aspect. But I think one of the biggest challenges, especially if you look at Nigeria, is that because the law is so vast, every time it gets discussed in Parliament, the parliamentarians get lost as to what amendments need to be made, whose interest then they're following up on, and you'll find it's taken them about maybe 4 years to be able to actually get anywhere with regards to that bill. And the problem is, again, when Parliament, is the next election cycle comes in and a new Parliament is there, you find that the IP rights holders, the lobbyists, have to go back in and train them as to what this new bill is about. So I suspect that might be a scenario here in terms of if there's so many competing interests in this one bill, it will be difficult to be able to get the right things in place. And also even with regards to amendments, you may win some here and you may lose some there. And I think later on I'll be discussing about the wins that I see in this bill and then some of the issues that really need to be reviewed. Thank you.
Okay, Carol, if I may, just a small contribution to your discussion. I have always wondered where the space for animators is in all these intellectual property conversations, because we have people talking about musicians, poets, and all that, but no one ever talks about animators. Yet they are a force to reckon with in our current economy. We see all their articles and products on TV and everywhere, but I don't even think they have a lobbying group or anything. So what would you say about that?
I Animators are definitely covered under the Copyright Act. They're definitely, there's definitely protection for them. They would definitely need to go to Kikobo, find other animators. I mean, with regards to the musicians, they came together and they formed these groups. And that's how they've been able to lobby. So animators should just definitely come together and then look for, a means to lobby with Kikobo. Kikobo is really helpful. You can go in there, walk in there. They may put you in touch with people who are lobbying for the same thing that you're lobbying for. So I suspect that that's the only way forward, like for them to actually start coming together as an association of animators to be able to ensure that their rights are protected how they want them to be protected, versus what we're seeing here, people imposing certain terms on them.
All right. Maria?
Mm-hmm.
Oh, you're
Yes.
back again.
Yeah.
Yes, I don't know if you got the question as I was asking Carol. Are we in the right direction, looking at an IP bill, or should we have been looking at probably an IP officers coordination bill? What have you seen in other jurisdictions that perhaps we could borrow? And basically the challenge is around Kenyans understanding intellectual property law, and does this bill then even make the waters even more murkier, in your thoughts?
I believe that we are in the right direction, especially if you look at what our neighbors in Uganda are doing. For example, they have they've done it quite well in terms of having it in one place. The idea is good, but the execution of it is what is wanting, in my view, because there's a lot more thought that has not been given to this. If you look at the way this bill is made up, you will see that they have, there's been a bigger emphasis on patents, very little on utility models, industrial designs, and technovisions. And then trademarks and copyright have gotten some space in this bill. Now, when it comes to geographical indications and even the anti-counterfeit, which this bill seeks to replace, there's not much, and that is a big problem. Actually, there's very little on counterfeit, except when it comes to, I think the section, either 33 or 32, that is talking about inspection 35, the last section in this particular bill. So perhaps maybe it's a compilation issue, because this is the bill that we downloaded from the KIPI website. A lot more needs to be done in terms of making sure that the administrative bit is sorted out, because this is where we have a problem. If you look at this bill, there's nothing to tell you how long, first and foremost, it would take between lodging your IP for registration. We know what currently happens, the 6 weeks that we usually wait for various, if you're talking about patents, for example, and how long it would take. For example, if there was a contest on that IP, how long it will take. There's a mention in this bill about if the office of the DG does not take any action within 7 days, then the complaint can be lodged with the tribunal. So for me, administratively, this bill is a nightmare. I'd want to see a lot more in terms of what to expect when you lodge your documentation. I would expect now that the government would be seizing an opportunity to actually employ technology in the application and management of IP. It's being done a lot in China. In fact, in China, currently they have about 33 online courts that deal with the IP disputes. So you can imagine, and obviously it's because of the amount of creative work or innovation that happens in China. So, with time we hope to get there. But back to this particular bill, it's a step in the right direction. However, there's a lot more thought that needs to be given in the administrative part of it. If you look at the powers that have been given to the office of the Director General, you'll just know what it is that I'm talking about. For example, he's the same person who's referred to as the registrar, and ultimate decisions are still made by the DG. So in as much as there's an opportunity for the DG to delegate, that ambiguity leaves a lot in terms of bureaucracy that a lot of people will suffer when it comes to the actual administration of this office. So it is my expectation that we'll be given an opportunity to actually inform from a stakeholder perspective a lot of what should go into this bill. There's, in my view, what they're calling the office, because they keep referring to it as an office, Intellectual Property Office of Kenya, is actually an authority. In my view, it's been established as an authority, and this will complicate issues. If you look at the current complications we have with just understanding the processes, even with CA and telecommunication companies. If you have from a user or consumer's perspective or a user's perspective, how do you actually ensure that you get services from this authority? My excitement with this bill was that we would be able to then deal with all disputes relating to IP from one source. But I can see even from this bill, most of the other bodies have retained their dispute resolution mechanisms, which will, it needs to be a lot more streamlined going forward.
Okay, Maria, just on the issue of dispute resolution, I noticed that technovation disputes are being referred to arbitration, yet there's a proposed IP tribunal.
Mm-hmm.
So I'm just wondering why the contradiction and how best should we proceed in this regard? Because in my opinion, original jurisdiction should be with the tribunal. And then if at all the disputes are not solved at that level, then we can appeal and maybe consider other options.
I think ADR should be adopted across the board. One, it should be a standard procedure for anyone whose IP has been infringed. If you look at it from your client's perspective, for example, what usually want is for the dispute to be resolved as quickly as possible. So if ADR offers you an opportunity to resolve the issue before going to the tribunal, well and good. I think the issue you're raising here is about the cost of arbitration. It should not be limited to arbitration, in my view. Arbitration should come as a, further down the road. We have mediation, that can be used to resolve disputes, but the timelines also are very important, and they should be applied quite strictly so that the users and holders of IP do not end up losing their intellectual property or the capital that comes with it, simply because the matter is stuck in ADR. But the idea of having one tribunal is a step in the right direction, because speaking from experience, having served at the Industrial Property Tribunal, we had a lot of issues with matters being lodged at the tribunal and simultaneously before the High Court and also the Commercial Division. And, with time, we were able to agree with the judiciary that all matters IP, especially with regards to the patents and utility models and technovations, ought to have been filed at the IPT as a court of first instance. So if we're going to have ADR, then at whatever level, it should be well thought out in terms of even the cost and the time, and then move to the tribunal, and then move to the High Court if need be.
Yes.
Okay, yeah, and I agree with you, Maria. I mean, when we talk about ADR, it should be subject first to the contract between the employees and the employer. And then I think now it can spiral down when, things become thick.
Yeah.
So I have a question for you, Carol. In your thoughts, does this bill affect the timelines in terms of registrations of the different IP regimes, patents, copyright? Should it speak more towards these timelines as well, in your thoughts?
Thank you, Liz. I think it's very difficult to kind of interrogate this bill in terms of how it's actually going to work, because instead of putting in, discussions about, or at least guidelines as to the administration process for bringing all these bodies together, it's actually just gone back into the laws that are used for the different types of IP. I mean, I'll talk about currently the trademark system, which I frequently use. And as compared to maybe other African jurisdictions, I would find that, it's quite progressive. Things move slightly faster than other places. But I just wonder if now they're going to bring in all these other bodies together, will there be enough resources to be able to fund the expansion of, certain departments that for sure need expansion? Right now, I think we've got about 4 examiners who look at trademarks. And I think in a year, I think last year, there were about 6,000 trademarks registered. So these 4 examiners have to deal with all those applications that are coming in. And, we've been fighting for more examination. They've been fighting for more examiners to be hired. And I just wonder now, will that then happen? Will more resources be put into now enhancing maybe other areas which obviously need more enhancement, like, for example, the copyright section, which definitely will need more input. So I'm a bit worried that the timelines may actually slow down. I'm not sure that they will, be able to scale up as much as they wanted to. The worst thing about the situation is that each body had a plan. They had a 5-year plan. They knew what kind of resources they needed. They knew who needed to be in place. They knew the areas that they needed to fix. We've seen with the ACA, they came up with recently with a bill, and now it's an act, and they've been working on regulations. Now this stops because you find that all the amendments that they made to their old act don't really seem to be reflected in this one. The same with with copyright. They recently made certain amendments. Again, are these amendments in this act? And will they have to start from scratch? So I just don't know whether there will be resources available to be able to scale up as much as each body had wanted to scale up. Are we moving backwards? And in terms of timelines, I just don't know. It's one of those things where you would hope that because now they're one body sharing resources, any savings that they make would be able to boost the different bodies. But then again, will there be a tussle between bodies that had maybe more resources available that have been taken away to be able to make them equal? I don't think all the IP offices need to be funded equally, but there's really no indication in this bill as to how exactly this is going to be done.
I think I'll also throw this in to Maria, and before Maria answers, I'll say for sure, talking about just the resource personnel, it becomes an issue. And I don't know if all of you have noticed that the bill lacks an interpretation section where, ideally the bill would be discussing and defining some of these important people or crucial personnel that we would need to execute this IP bill, yeah? Because we have the Copyright Act to talk about the inspectors, we have the examiners, who is an examiner in this situation, what terms are we also going to be using? So Maria, over to you in your thoughts. Just consolidating these offices in terms of timelines, in terms of even just executing some of the mandates of these different directorates as put in the bill. What do you see in terms of a better infrastructure?
So are you asking about how fast it should be done, or the recommendations on implementation?
The recommendations on implementation.
Well, it's my view that, well, you see, first of all, these bodies already exist independently. So getting them into one, okay, the government works, getting everybody into one building will take forever. But in terms of administering how it's going to happen, because remember the way the bill proposes is that everything will be run centrally under a DG. So I think the first thing will be to get the council into office, which before I speak much about that, I want to just if I could just direct you to the bill itself, so that we look at the council. The composition of that council is, first of all, it's very government heavy in terms of representation. You have 3 permanent secretaries, and one of them, their designation is not known. You have the ICT PS represented there, and you have the Treasury PS as well. Then you have, sorry, then you have the ODPP is represented, I guess, because of the anti-counterfeit approach, the AG, perhaps because of trademarks, and then 3 members, this is where it becomes crucial, 3 members appointed by an undesignated CS. So we still don't know which CS that will be. And these 3 members, there's a further qualification as to their, appointment, which says that they must be university graduates. Now, if you look at some of the views from the stakeholders, is that first of all, the representation on that council is very minimal, or is non-existent, if you would. But if you go further and say that you will have to have university graduates, then you lock out a lot of deserving representation on that board. I think there needs to be a very clear and deliberate attempt to ensure that we also have youth represented in this council, because a lot of the bulk of the creative work in this country is done by young people. You also do not have representation of the LSK. This might appear selfish, but the truth of the matter is that you need the lawyers to interpret these laws and to even provide some strategic direction in terms of the council. So there's been, in terms of even just getting that office together, that's the beginning. I think that's where they'll start, but they've started off on the wrong foot in the proposals. I would want very much to hear from these people about where we'd be going with that particular approach. But my proposal is that since there's already the office of the IP, you have Kipi, you have Kekobo, you already have the trademarks under the AG, then those should proceed. But in terms of the composition of that council, which will also be quite funded by the government, then we need to have a proper critical approach so that we get it right from the beginning.
All right, so David, Bernard, and Nonini, there was this royalties fund that was announced by the president recently that did not make people very happy for obvious reasons. Now, the issue that I have been hearing about that fund is that there's no transparency in terms of access to it. How do people go about it and all? Could you maybe highlight some of these processes so that our audience could be in the know? And what qualifies one to access that fund?
Bernard, you want to handle that, or Nonini, as a former CMO?
Bernard handle it, and then I'll add on top.
Okay. Okay, so I think the president made 3 statements. One, he announced that there would be a framework that is being worked on between the Ministry of ICT and the Kenya Copyright Board. And for around that, he said that there would be a distribution of about 200 million every month. So I would like to just for those who maybe didn't understand this as it was put in the statement, is that is not money that was the president pledged. What he referred to is in future that out of the framework that's being worked on, it will be possible for the collective management organizations known as the CMO to distribute up to 200 million every month. So that's a projection. It may be more, it may be less, but that's a goal that they are working towards. The second thing that the president announced was that there would be 100 million that he directed the Ministry of Sports and Culture to release. And the president was specific to which parties this money would be released to. I think he said artists, musicians, and there was a third entity as well. I don't remember right now.
Actors.
Sorry?
Actors.
Actors. Yeah. So this money was to come from the fund that I think I'm not sure, but if you remember a while back, the government passed a direction that the gambling companies would be taxed and that money would go into a certain kitty. So my understanding as of now is that this money would be handled, the distribution of this money would be handled by the ministry and the copyright board, and probably distributed to artists that are registered through the CMOs. I'm not sure. That's what I've collected out of discussions with the Kekobo. But the money has not been released yet. So as of now, there's no release of that money. I think part of the challenge that people went through was that there are a lot of artists in this country, and 100 million, if you divide that money equally across all artists, just by going through what the artists registered at the CMOs, you probably end up with about 15,000 artists. If you divide that by 100 million, it's an amount, but it's not an amount that will get members out of the trouble they are in, but it is an amount that the government has pledged. So that's my take. I'm not party to how they arrived at 100 million, and that the fact that the money should be distributed to artists. I personally think that, and sorry, but this is a personal opinion, that the 100 million could be put into a different use that would help this generation and future generation, than to divide it across, like 15,000 members at once. So I feel that if the government can maybe give another 100 million, that is specifically supposed to be to set up something that would be long lasting and that would benefit rights holders in future, that would help as well. That's my opinion. And I'm not very informed about that money, to be honest. Also, I have made an effort to stay away from the discussion about that money out of past experience.
Okay. Nonini, you had something to say?
Yeah, if I may add to what Bernard has said, as Creative Society of Kenya as well, we do not know how that money is going to be channeled to the creatives. But what I mentioned, like even on the IP issues, proper workshops need to be done for artists and consultations so that we understand how the industry is. I feel personally it was premature to announce that amount, like coming to creative, especially the music sector. Because currently as CSK, we are working with different organizations and NGOs to collect data out here to understand the real effects of COVID-19. How much money have creative lost? Salaries, people can't go out and perform. What are the losses that we've incurred? It's quite important we equate all these amounts so that we can be able to engage government, so that we know what amount they can put aside to cushion the creatives. But when you have 100 million and we have 15,000 musicians out here, I don't think that money can cushion any one of us. And plus, it's not just for musicians alone. It was announced for actors, musicians, and artists. And by artists, we're talking about the painters and all these people. So proper consultations and workshops should have been done to understand the losses that the creative industry, especially the music, is undergoing, so that we be able to make an informed choice. But bringing the point back home now to the IP, to the bill that we're discussing today, I'd also like to mention, I've read section 10A, if I can just refer to it, they're saying the trustees of the council will invest monies on behalf of the council. They'll have board of trustees who can invest money on behalf of the council. From the background and the interactions we've had with the CMOs, I think that's a very bad idea. I think that section 10A should be stricken off. Nobody should invest anybody's money, especially the creative's money. When you say somebody's going to invest money and we don't know how that money is going to be invested, we open loopholes for corruption. So I think Section 10A should be stricken off. Sorry, I divert. I came back now to the IP, to the bill itself that we're discussing.
No problem. And that's a good thing to point out, because I was having a conversation about this particular Section 10A, and I realized it features in many acts of parliament where investing, these councils and boards that are created can invest. So perhaps now I think this bill is also opening eyes for us, especially the non-lawyers, to see how you can participate in the lawmaking process and be able to, raise objections, perhaps, or maybe issues of transparency when we're talking about some of these things. But this is not a peculiar provision. When you look at some of these other acts of parliament as well, you will see that it predominantly features. So now let's go back to the issue of industry representation. And I've seen that Ms. June has highlighted, of course, the council has not highlighted the participation or the inclusion of the Minister of Sports, Arts and Culture. Again, a big question mark, yeah, in terms of, this whole inclusivity. Then, for you, David, who has been previous, you've been privileged to serve as a director at Kekobo. The Act now talks about the DG providing for committees. Now, in your view, do you think that for a citizen to be able to participate as a committee member as opposed to a board, which now, of course, it is conspicuously missing in the bill, would these committees be effective as the boards that have been created in the previous regimes that will soon, exit after the bill is in place?
I mean, first of all, I see a big sense of, I don't know, it's of omission or mischief by leaving out the Ministry of Sports and Heritage, which also leads me to wonder where traditional knowledge and the Cultural Expression Act sits under this new dispensation, which was previously housed under under Kekobo, and I wonder whether that's just going to now be housed under the Ministry of Sports and Culture and hived off from being administered by this new bill. That's an interesting question we need answered. The fact that there are only 3 non-governmental positions held, as I mentioned earlier, will already threaten the representation of creators. And as you've said, the bar has been set really high. We have to have degrees and whatnot and so on and so forth, which cuts out, probably 60, 70%, 80% of creators who potentially could sit and who actually have a right to sit and represent their community on such an organization. So I definitely think that needs to be looked at a lot more and discussed. The issue around, I think, youth representation as well within creators' rights is very, very important. And we hope gender mainstreaming will actually happen this time around. Yeah, I think those are my views on that. I don't think it'll be as efficient because, as you said, it's very top heavy with government officials. It might as well just sit within a ministry's headquarters.
Yeah, and you see in the Act, they have highlighted that the Director General can, through I think their directorates, they can have like some sort of committees or subcommittees of some sort. So my question to you is, as a committee, would their impact as citizens be felt more as opposed to how we have been, we operate as boards?
I think we'd get a lot more clarity if we understood the organogram and how the flow of decision making will happen. Once we establish that and we know the impact of decisions by subcommittees and committees and what the process of decision making is, we'll be able to give a better view on that. But the minute you start breaking it down, you move a board into a directorate, into an office, we've seen this happen with other parastatals and other organizations, where they just get quashed and they just disappear. We hope this won't happen to especially copyright in this case. So yes, I can't really comment on the effectiveness right now.
Yeah. Okay.
I'm just seeing a question here that is addressed to no one in particular. Someone is asking, what is the place of traditional knowledge as a critical component of intellectual property in Kenya?
Yeah, and let me just, as I direct this more to, I think, Maria and Carol, the bill has now introduced geographical indications, which we've not had geographical indications in our IP regimes. So one, what are your thoughts in a bill introducing a new regime of intellectual property? One, two, have we has it been well drafted or, covered in terms of the geographical indications? And then three, because in my view, as a scholar, I've seen that there's that interface and interaction between traditional knowledge and cultural expressions and GIs. What would be your thoughts in terms of this? We can start with you, Carol.
Okay. Yeah, so I'm like I said, the act was so wide. I was only able to, briefly look at things. And I think with GIs, what we need to ensure is that it is in line with TRIPS. It looks like the way in which they've done the sections was very hurriedly put together. I think there needs to be a review of how other African countries have been able to enforce GIs. I think there's a school of thought where, things should be protected, get communities together, get them to get some sort of certification, and then they're left by themselves. I would have liked to have seen that there is some level of government intervention with regards to education of how to maintain a GI, some funding towards enforcement of these GIs, because at the end of the day, this is a pride, something that the country should be proud about. I was recently was looking at the story of rooibos, which is a root found in South Africa, and pepperdew, which is a small pepper which is also found in South Africa. And the first instance, with regards to pepperdew, the South African government did not assist the growers of the pepperdew trees to be able to protect as a GI, and then it was taken and it was registered by an American company who now has registered it around the world. The farmers themselves cannot call their product pepperdew without a license from this American company. The same thing with rooibos. A French company decided that they wanted to be able to grow it in labs in France, and were therefore going ahead to trademark it. It took a very long time to get the government to actually go in, negotiate with the French government, go back into WIPO, negotiate with them, and now South Africans can be able to be proud of the fact that you can only call that root rooibos if it actually grows in the South African region. So, GIs is one thing where it's great to have, it's idealistic, but again, without any support, it is very difficult to enforce. Communities do not have the kind of money to be able to go around the world to ensure that we're enforcing it. But what we also must be careful about with regards to GIs is that it is reciprocal. So if, for example, the government does go in and try and push GIs on behalf of communities, we have to then accept GIs that are around the world. So if we're talking about things like, feta cheese or champagne, for example, then now we have to be able to protect those. And do we have the systems in place to be able to do it? So the fact that it's just been lobbied, thrown into this bill is quite sad, because it definitely needs more thought. And another thing, why is the term for GIs only 5 years? You have to renew your registration for 5 years. Communities will not be able to do that every 5 years. Even for a simple trademark, your protection is at least for 10 years, and you can keep renewing it. Why have they suddenly decided for geographical indicators that, the term is 5 years? Is it a money-making scheme? And I think that needs to be reviewed. Yeah.
And before we go to Maria, when you look at how GIs protect communities, I mean, now we already had passed the Traditional Knowledge Act, and of course, we've seen it had been at Kekobo. Kipi also had an office that was looking also into TK. And I know also at the Kenya Bureau of Standards, they have, some IP also situations that they take care of there at the community level. So in your thoughts, do you think the TK Act should also have been considered here? If yes, no, maybe, general thoughts.
Yeah. Thanks, Liz. I think the thing is that we need to be able to harmonize all these laws. I mean, there is room to be able to protect TK within the trademark framework to a certain extent. There is room to protect it within the copyright framework. There is room to protect it in the GI framework. I think the fact that we have different bills that deal with different aspects of it is a bit confusing. And to be honest, even just as practitioners, trying to be able to strategically figure out which is the way forward for communities or persons who are using traditional knowledge or want to exploit it, it becomes very difficult. So, from my perspective, that discussion needs to be a separate discussion. It needs to be able to look at what is the best strategy as the Kenyan government to be able to protect traditional knowledge, and then look at what other options are out there, and then create a bill that will be a one-stop shop for that in particular. Because as the world grows, we are now realizing that we do need to go back into nature, and some of these things are existing in our country. But if a client came to me today and asked me to help them protect a route that European company wants to buy, I would be hard pressed to figure out where exactly we could go with that. So that is a bigger discussion, and it's unfortunate that now we can no longer have it, because this is what we've been presented with as only being able to use GIs and possibly trademarks and certification marks for that kind of those kind of inventions.
Okay, Maria, over to you. Your thoughts? The bill introduces GIs. What are your thoughts in how it's done? They have done it, the execution, and possibly your thoughts on the TK Act being, possibly part of this bill.
First of all, I think it's a good thing that the GIs have been introduced. In my view, it's about time that we actually had this protection, actualized. My reading of this bill is that the sections that have been provided under Section 30, the several clauses that talk about administration of GI, even the term, and I'm particularly happy with the provision for the term, because it talks about the term of the GI continuing to persist or exist as long as you have characteristics are still available, or the quality of the registered GI is still existing. So the protection will still continue. And even the dispute resolution that has been provided for in terms of the GI. What I'd say is that, having had the TK, and I remember I can see Maricela is one of the participants, and we discussed this, I think a year or a year and a half ago. And I think even Dr. Rutenberg was there. And the fact of the matter is that all these acts and all these laws, having them in place is a good thing. The application of the law, or how we administer the law, or even the justice when it comes to protection, is what is important. For example, when you're talking about GIs and traditional knowledge, and you're talking about a centralized registry, how effective is that? So for me, what I would be looking at, especially in terms of GI and traditional knowledge, is ensuring that these services are devolved, okay? So that communities like what Carol was talking about, communities that would want to register simple things like traditional knowledge or GI, how will they do it? Because this is about the ability to register or protect your GI or TK is based on your access to those services. So that's the first thing I would be looking at. And even the fees, is it something that the communities can afford to do? And how can they keep up with knowing that the protection exists? There's talk of agents, communities or producers being able to use their agents. That needs to be managed well, so that you have communities actually having their GI protected and not exploited by agents. So for me, it's a good thing that it's been introduced. It can be, a lot more can be done in terms of the regulations, because none of this, the bills that the bill as it is, none of these acts, regulations have been included in this bill. So there will be a lot of work in terms of the regulations and the administration of this bill is concerned. But yes, to the GIs and traditional knowledge can be protected under the bill.
All right, thank you, Maria. Carol, there's a question for you here regarding traditional knowledge. And Jackie is asking, what is the role of the World Intellectual Property Organization in some of these blatantly mischievous registrations of IP by strangers to the knowledge?
Okay.
Carol.
Sorry. Yeah. So I think, to be able to understand IP simply is that it's a territorial right. So at the end of the day, if you want to be able to protect your work in the United States, for example, then you've got to go and register it in the United States. Somebody else may register that right in the United States, and you may now have to go in and say that you've got a better claim to this right. For whatever reason. The World Intellectual Property Organization does have certain statutes and laws that allow you to protect well-known brands. So for example, if, let's say, for example, Safaricom is a well-known brand in Kenya, and somebody goes into Mozambique and decides to want to register that trademark. Safaricom may try and prove that they're a well-known brand in Kenya, but they may not be able to get protection for being a well-known brand in Mozambique. So at the end of the day, they are protections, but for big, huge global brands. So we're talking about the Googles and the Amazons of the world, where, it is clearly a blatant, theft, because those are well-known brands around the world. Now, unfortunately, because we don't promote our brands as well as we should outside of our country, when they're taken up by somebody else, who may actually not even have any connection to the brand itself or even the invention itself, we may see them as, coming to steal something that's of Kenyan value. Now, if we go back to the point of where Nonini was talking, education is key. So if you see your brand, actually gaining traction in other countries, then it's upon you to be able to go in and register, your IP there. Unfortunately, because of the territorial nature of intellectual property, it's really difficult to be able to, enforce a right that you don't have any sort of, registration to, or it's not, well known globally. So, the government maybe needs to do more work in terms of educating Kenyans as to protecting their work. And I think, especially with regards to like TK, traditional knowledge, traditional methods of doing things, that really is where the government should come in, because those are the things that, the people who use them would not even probably even know how to protect it within Kenya itself. So if the government is able to step in, create programs where, these things can be protected as GIs, for example, in Kenya, then at least it gives them an opportunity to be able to enforce that in other countries. And WIPO certainly helps with that. WIPO has a list of, registered GIs. It's easily available. If you type it into the WIPO website, you can be able to see them. So it's upon the government to really start taking care of its people and ensure that, the right regimes are in place to be able to ensure that these things don't happen.
Yeah, and before we move to the last round of questions, just to add on to this conversation about, just the conversation about TK and how it's, on a cloud. I think one of the things we need to really think about as Kenyans is what is this traditional knowledge on cultural expressions that we are talking about, and who owns what, right? Because when you look at our former, or rather, when you look at the 844 system as it was then, when we did arts, culture, arts and music and craft and all that, right? We had a lot of exposure to some of our traditional elements and culture and, tie and dye and all these things, right? So I think it's important for us as we discuss the possibility of a register or some sort of repertoire of some of these community properties, to then have public participation so that we know who owns what, so that then we are aware, because already the TK Act as it is in place, it sort of talks about even just how Kenyans, us as Kenyans, how we use property. So what I thought was quote unquote public domain, then I use it, for example, maybe in a song, I use a Pokomo lullaby, or I use a nyatiti in a song. Does that mean I will pay a particular community for using the nyatiti? There's a lot of issues there that have not been answered. So I think now we can proceed to the next, the last round of questions is, in your thoughts, in the different areas that you are, feel biased about. And we'll start with, I think, Nonini, perhaps in copyright. What do you think the law could have done better, or this bill could include in terms of what is missing? Bernard, also, it would be interesting to hear your thoughts on maybe software. Are there any provisions that you feel could have been, in place? For you, Mr. DJ Delight, aka David, what do you feel like in terms of the copyright section? What could it have done? What can it do for someone as a DJ, for example, or generally as a creative, maybe in music, in the arts, and whatnot? Yeah, so we can start with you, Bernard.
Thank you. I think I would want to see this bill focus a lot more on technology in terms of nurturing our youth, so that we can be able to take advantage of the fact that we have a lot of software developers and innovators, people creating technology products. I think I saw the other day, Kenyatta University created a ventilator. The thing is, the law is there, but then the enforcement and implementation is not as strong as we should have. So you end up with the people that hold intellectual property, but it's not helping them. I was having a chat yesterday with someone, and I was telling them that in Microsoft Word, when you type something that is not in the dictionary, there's a little red underlining that comes under the word. That red underlining is actually trademarked by Microsoft. And anybody who wants to use the same feature has to pay Microsoft for that. We need to get to that point where if you create something, you can make money and live off that product in this country. And I don't think the bill addresses technology sufficiently. So I'd want to see a bit more input in that bill, in that respect. Also, let me just mention the two other things. The issue of stakeholder involvement in the board composition. I think that's very important. Three slots, I don't feel like those are sufficient. And secondly, what Nonini had raised about education, we do need to educate a lot of our people about intellectual property, so they know that intellectual property is a form of currency that they have. It's having a right in something that you have invented or created is the same as having a piece of land, and you can sell it or make money out of it long term. I think that would be it for me.
Okay, so before we continue, there's a gentleman who's been raising his hand for the last 30 minutes.
Tom.
Tom, please, you have the floor. Tom, are you there?
His mic is muted. Yeah,
it's on. Okay, so we'll continue with the. Sorry, Tom, we have you.
Yes, here I am.
Yes, please proceed with your question.
I have very few suggestions which I want to contribute to this. I went through the bill. As I speak, first, I'm an ADR professional. He's a arbitrator and mediator. At the same time, I'm also an IP professional, though not an advocate. So my point may sound a bit biased, but then I'm representing a huge number of people. So first of all, my first point, I think the merger of these laws together is very important, in my view, because we'll be able to promote IP in the country. Right now, people don't understand the difference between copyrights and patents. And I think this is an opportunity for us to be able to bring this out to the public, for people to understand IP generally, so that even if you're adding some aspects of IP, like geographical indications, it becomes easier when most people understand the value, the importance of IP. Yesterday, I talked to an advocate who has a farm, actually has a school, and she told me she does not need to trademark her school name because it's a company. I don't know, but she's an advocate. So I realize there's a lot of misconceptions. Education be important, but this bill as it is, it becomes law, it presents an opportunity for promotion of IP in this country through education and sensitization. Now, my key points, number one, I look at the admission of agents or attorneys in the case of trademark and patents. First of all, I believe that patents require technical knowledge because you will need, that these things, you have to have a reason behind it. You will need to interpret, you need to draft a patent in the language of a technical person. If it's a patent in chemistry, in biology, if a patent is maybe engineering, you will need that background for you to do a proper patent drafting. Therefore, comparing the Australian case, they have, I think, 9 subjects you need to pass or you need to be well versed in for you to be a patent agent. But I don't think the same should apply to trademark because the issues in trademark are more perceptional. I happen to be a lawyer, at the same time also a marketer. A consumer behaviorist knows very well what trademark dilution is, which you've not included the bill, by the way, and how it comes about. So my thinking is we should have different categories of agents for trademarks, and agents for patents should be thought about differently so to have effective people in those areas. And therefore, we should not merge the two of them. I think that should be section 190, and that should be clear. Of course, we also look at how we are using the word advocate. Some people are actually lawyers, but don't care about being an advocate. We don't want to be that. I'm an arbitrator, I'm satisfied with that. But I should be able to contribute and assist my country. So don't just say, you bring these certificates here, then you become a, no. Let's look at a way we are recruiting the agents. I probably would suggest one thing more. Do you think we need to have some qualifications for someone to be admitted into this agency? I think that should be a good opportunity for the IP office, and opportunity in terms of probably revenue, I would say that. And at the same time, the opportunity for us also streamline the practice in terms of IP services. We may need to have.
Thank you.
Let me add 2 more, please. Just 2 more.
Just wrap up.
Very quickly.
We're pressed for time.
ADR. ADR has to be properly used in this bill because if you don't do it well, I look at where we are talking about technovators, and you find that the enterprise may need to choose an arbitrator. Suppose they choose someone who is not a professional, you're likely to have more problems in your tribunal. I think we need to use the ADR properly in this bill. I think you've cut me short, but I really appreciate for the opportunity. Thank you.
Thank you for your contribution. So we'll go back to the panelists. So over to you, Nonini, your thoughts on what could the bill include that you feel is left out, or what can it improve?
To me, I have some pros and I have some cons with the bill itself. So probably I can say, let me start with the positive. The bill is a positive proposal, since IP will be centrally managed. That's what I think. The requirement for the CS will be for him to make and review IP policy for every 5 years, which is a good thing because as of now, government has no tangible, successful policy on key IP sectors such as music. Nobody's holding them accountable. So the move to set up also the tribunal, to me, is also very positive. But I think they stress more on educating judges so that they be more versed with IP matters. That's why most of these matters, currently have matters in court, are usually referred to mediation and arbitration because most of these judges don't have good knowledge on IP. On the definition of copyright under the bill corporate register, I think it needs to be expanded to incorporate technology. Sahi while tunaenda manze, kuna vitu kama artificial intelligence manze, that should be incorporated. Kuna vitu kama gaming. Kwanza saizi on YouTube, the most paid creators are gamers, kids, Coming back to my industry specifically, I think when it comes to things like this other entity, for money is passed down to the CMOs, which is a good thing to end collection disputes. And also, unfortunately, the draft doesn't incorporate issues of governance and transparency, the ones I've raised, even for the monies that are going to be invested by the trustees of that tribunal. This bill really, really has to be tough on governance and transparency, because hapa ndo tumekuwa tukiumiaga kama wasanii. I think those are my comments for now.
Okay, over to you, David.
Wow. Just first, I'd like to thank Victor and Zomo, who I've seen here, who's just reminded us that, and I'd actually forgotten this little fact, that the TK, responsibility of TK was moved to Sports and Heritage when they amended the Act. And it makes it that much more important that actually the Ministry of Culture, of Heritage, Sports and Heritage does get represented under the new setup, because then we have access to that. I just feel it's going to operate on an island on its own. And I feel it really should come back under this. Another thing, again, back to Victor, I remember reading an article and I was looking for it just now in 2014 when we first started this conversation. And the discussion about the organogram, which I'd raised earlier, is the fact that back then, the wage bill for this merger was actually going to nearly double. It was going to go up by about 120, 160, let me get the facts, 116 million back then in 2014. So it's obviously a lot more now. The only saving we're going to make is about 10 million off board meetings, etc., board expenses. So that's another aspect that actually does need to be looked at, because as we're doing all this, it's again, the question I asked right at the beginning, why are we really doing this? Are we trying to just appease bilateral trade agreements, or are we actually trying to be more efficient, save money? And we're going into an era where we know the government will have a lot less funding after we get through this COVID period than before. So that becomes that much more important, in my opinion. The issue around the transitional committee, there's a transitional committee right at the bottom that's of the proposed bill that's meant to be the caretaker committee for about a year. And you know, the constitution of that committee is slightly different from the final group that will actually take over the reins. That's something else I think that we need to discuss a little more, like who will really be representing that transitional committee. On a positive note, if the outcome of this is that IP can be seen as collateral, and I know one or two of you have raised that issue, if it can be seen as collateral, so that, let me just do a shameless plug, so that people like these, Teparuka, representing Kenya creatives,
Peperuka.
I just say this is not an endorsed action, paid for advert, no, is that people like these can actually use the IP as collateral, as they do in many other countries and much more advanced, who have much more advanced IP systems. If it were able to achieve that, I'd be all for it. End of story.
Yeah, and before we move to Maria and Carol, I mean, I think you're right about IP as collateral. I think the bill could do better so that we can give a backbone to the Movable Property Securities Act, because it provides for IP as collateral, but you know, even the banks have been looking at it and they're like, okay, so now, you know, so I think for sure there we have a lot of room. So over to you, Maria. You know, areas that we feel are not covered in the bill, and then also please address the constitution of the tribunal as it is right now. You know, will it be sufficient? What do you see? Because I see that it will have a lot of work, right, with all these regimes now put together. But you know, we'd like to hear more of your thoughts in terms of the constitution of the tribunal as you address any other areas that the bill could, you know, delve into.
I think the bill needs to be very, especially on, you know, we've talked a lot about copyrights, and I've seen even some comments here, and people feel that this discussion maybe is too copyright heavy, but there's wide areas of IP that have been covered. In the bill, the only time that you see the anti-counterfeit talked about is when you're talking about enforcement. So I'd want to see more on how the ACA bit will be covered in the bill, especially because now this is a criminal enforcement. So that particular area will be of interest, especially to practitioners, as well as the manufacturing sector. Now, when it comes to the tribunal, what ordinarily I would have expected is that then there will be a heavy consideration of all manner of IP to be dealt with by the tribunal. Pretty much has borrowed from the existing IPT. I haven't seen much of changes. It will have 7 members. My suggestion will be this tribunal will need to be expanded to the counties or regionally. I don't think it makes sense to have one just sitting in Nairobi. Alternatively, like I had suggested earlier, let's have this tribunal go online. Let's have digital tribunals where people can file their different complaints, with regards to trademarks, utility models, patents, copyrights, etc. The copyright tribunal was already existing, up and running. Liz, you know a lot about that. And I would not want to see us claw back on the gains that have already been made in specific areas of IP. Let's have the tribunal be more efficient, is what I would say. Include more experts in the area of software development, especially that's a big thing in Kenya. Gaming, as Nonini had said earlier, there's a lot of IP development that happens in the workplace. I think a lot of people or even employers and employees do not understand how to, manage that. I think also those who sell their, especially software, when you look at software contracts and many of the arrangements that private entities and owners of software get into with third parties, there's a lot of areas there that need to be covered in terms of IP protection, so that also joint IP ownership is covered in more detail, especially when it comes to software development and use. So I'd expect to see more of that. I'd expect to see a schedule on the fees payable. I don't think should be prohibitive, because this area of the creativity or creative industry, a lot of these people struggle just to get their creative works out there, and placing an extra burden on the cost of protection, that should be a consideration. I'd also like to see more in terms of the administrative nature of this office or the authority. Like I said, it's going to be divided into directorates. So I'd want to see a more detailed, if you would, an organogram, but not so much an organogram, but just how each department will be structured, and the kind of services that will be offered to the public need to be very well clearly spelled out, and remove most of these responsibilities and powers on the one office of the DG, and have those spread out in such a way that we reduce bureaucracy and ensure that IP is effectively managed in Kenya, and not for the selfish gain or abuse by some institutions. Thank you.
Okay, so just to clarify, Maria, we're saying that the bill would be more functional if it was to directly address the Directorate of Copyright, Directorate of Trademarks, Directorate of, like it's specific, right? As opposed to then, the DG deciding on a whim, oh, today we'll have copyright, but tomorrow it will be copyright and trademarks, for example, yeah?
Yeah, and I expect that this will be covered in the regulations. And that's why, for me, passing a law without the policy, because I've seen when you're looking at the preliminary parts of this bill, they're talking about having a policy that will be established after, and even a strategic, and the policy, I think, would be renewable every 5 years, and also a strategy, an intellectual property, a national intellectual property strategy. My view would have been that, and I'm sure there have been numerous discussions amongst the different sectors, these should be put in place first. Then we have the law, because if you're having a law that is chasing after technology, remember technology is new and dynamic and it keeps changing every day. So even talking about a strategy or a policy after 5 years, in my view, is not very well informed. And obviously, is someone who doesn't understand how dynamic different areas of IP are. So we need to be flexible in terms of the adapting to the technology itself, so that the law is not chasing after the technology. Then we're also required to have the regulations in place so that even the Office of the Director General is not, like you say, too inundated in terms of making all the decisions at the expense of the IP holders.
Yeah, and it's a good thing you brought up the IP policy. It's been a conversation for the last 10 years. We have a not so well drafted draft, which was borrowed a lot from the South African jurisdiction. So, and I think when we're talking about almost 10 years now, we don't have an IP policy in place. It's still somewhere hanging around. I mean, I think then dangerous times, we need to decide how to, put our ducks in a row. So over to you, Carol, your thoughts on what the bill could have, is yet to sufficiently address. Yeah.
Okay. So when I was looking at the bill, I was looking at it from the perspective of, work coming into Kenya. I was looking at investment coming into Kenya. I'm looking at what are the barriers to Kenyans accessing technology and using it here, where, and in that case, we're looking at licensing regimes. And I was very disappointed to see that the licensing regime that was in the Patents Act has now been replicated here. The licensing regime that they've put in place in terms of having an overview of what kind of licenses will be allowed to be registered in Kenya is very restrictive, especially with regards to persons who are almost, going out there with their hands open, asking to be allowed to use a certain product or certain technology in Kenya. The restrictions are, I think, over 29 restrictions with regards to the type of licenses that will be allowed or that Kenyans will be allowed to register with the IPO. And when you look at them, I was looking at things like you can't import certain things if you can find them in Kenya. The license can't dictate a royalty price that the government feels is prohibitive. There's restrictions on where you can source the components for these technologies. The government won't allow it. And I think, we've got to be honest and say that licensing agreements are made with willing buyer, willing seller to a certain extent. So if you go out there, broker a deal, with a big company or even a small company to be able to bring a product into the country, and then you come back to be able to register that license in Kenya, and then you find that there's a whole host of things that need to be in that license agreement, very quickly the other party who's, has agreed to license you that product or technology, very quickly those, shy away. And I've had situations where that has happened. The real situation is KIPI at the moment doesn't really, hold this too strictly, but what stops it from happening? And I think we've got to be able to look at, how can Kenyans progress? Is this allowing us to progress? The same thing is also in the trademark regime. Again, oversight onto these licenses. Privacy is an issue. If a company has, secrets trade secrets that they will pass on to their licensees, KIPI has to be able to see this, and that is in breach of that trade secret to a certain extent. So at the end of the day, is this bill really enhancing our opportunities to be able to get technology into the country? And then also, on the other hand, if we have these kind of, impositions that we're putting in towards these kind of licenses, will other people also impose the same on us Kenyans when we go out there to license our technology? I was also really surprised when I saw the penalty for patent infringement, especially knowing patent infringement. The penalty at the maximum is a paltry $500, and we know the patent sector is a huge sector. If we just look at pharmaceutical patents, I mean, $500 to be able to infringe on a patent and walk away and maybe have a few years of jail term doesn't seem right to me. I mean, if I was a patent holder, I'd be very worried about bringing my patent into Kenya or even it being infringed because I don't think it'll be protected. So I think that needs to be reviewed. That definitely needs to be changed to be a bit more stringent, to be a bit higher in terms of, the penalties. Maybe it should be on a scale, and especially with knowing infringement, this person knowingly knew that they were infringing on a patent. I mean, it may be different if somebody was unknowingly infringing, then maybe the patent, the penalty can be $500, but at the end of the day, this does not bode well in terms of investment. I was also looking at, opposition in terms of if somebody's registering a similar trademark to another person, they have to give them 30 days notice. Now, the bill does not explain when the 30 days notice starts. It simply just says that you've got to be able to give them 30 days notice that you're going to oppose their trademark. Unfortunately, a lot of these bigger companies who have really valuable trademarks are not in the country and hire watch services to be able to, look at the trademark journal and see whether there's a similar trademark that's, attempting to be registered. Now, that watch service may give them that information a month down the line. And now they've passed the 30 days that they should have given notice to the other person registering the trademark. And there's penalties towards that. And so I think that also, again, needs to be reviewed. I think if there was a policy in place, like Maria was saying, then there will be at least some sort of rules in terms of the way in which we frame our bill. What are we looking towards? Are we looking to get investors? Are we looking to Kenyans, registering their IP? Or are we just simply putting an IP bill together so that we can say we have an IP bill? So, those are the major things that I was looking at. And, it's important that these conversations continue to happen. I think it's unfair to be able to, pass this without proper stakeholder interventions being heard. I think anyone who's pushing for amendments should do this publicly, share these amendments, because at the end of the day, if we don't know what, for example, Kekobo or ACA or even the creative sector have said are their inputs, we would be able to watch whether those things are actually in place. So there needs to be some sort of sharing with regards to the things that we find that are wrong in the bill, that need to be changed, need to be amended. I agree that the train has left the station. This bill is very likely that it will be passed. So if we do not share with each other, we're not going to be able to be our brother's keepers in relation to this. One last thing, I am a big proponent for the recordal system for trademarks and with regard to anti-counterfeiting. The ACA made some proposals towards this. It wasn't the best form, but it's unfortunate that this also got left out in the bill. So, a lot of rights holders that I work with really would like a recordal system in place so that they can be able to allow the people who are actually at the port, the anti-counterfeit agents, the tax authority, to be able to see whether this is a counterfeit good or not. And unfortunately, that has been left out. So, there are many, many things that I think we haven't been able to cover today, but hopefully, this conversations continue. And we
all right, thank you so much. So I think.
All right, thank you to our panelists for your views and suggestions. I saw Francis, your hand is up, and Brandon and Jackie. Francis, I'll give you 1 minute to air your views. Francis? Is he on?
Francis, we can hear you.
Yes, yes.
Yes, so mine is, I'm from the University of Nairobi. And mine is just the observation that the bill is top heavy on, you can call it regulation as opposed to facilitating business. So for example, one of the things we are grappling up with the universities is that there are no laws, for example, that allow somebody working in an institution to commercialize their IP. Because there are laws that say you cannot, for example, trade with the employer. So as soon as you want, for example, to set up, whether it's a startup, whether it is an incubator, they bring these laws about you are an employee, you cannot trade with the employer, or you cannot, there are now those laws that are saying you cannot set up a business. Now, how is it going to work where you want startups or SMEs to come out of innovation and you are saying the person who has that IP cannot commercialize? Now, those laws need to be sorted out and clear. And I have put some comments on the board. Basically, some of the issues that need to be tackled around that would basically, it would help if they were reflected in the bill. But basically, moving further away from IP, that is the process after the IP, the licensing, the commercialization, and the technology transfer component, it is not there in the bill. And that is basically where the money is made or lost. So those issues post IP, because IP alone, to try and regulate or manage IP is expensive because it is an expense. Now that IP need to be facilitated to be either licensed, commercialized, or transferred. Now all the laws basically tend to inhibit that because they say the IP or whatever belongs to the employer and you cannot trade with the employer, you cannot, the banks cannot lend to IP, there's no provision for that. Venture capitals is there. There is no there are no laws governing venture capital. They basically are operating the way the online lenders are. At least central bank is coming on board to regulate that bit, but there are no laws on that. So there need to be laws that regulate that sector so that basically the IP can then be commercialized or technology can be developed and then transferred to the people who can commercialize. Now that is not there at all in the bill.
So in a nutshell, Francis, sorry to cut you short, you're basically saying that then the bill should factor in some provisions for technology transfer, especially for public institutions, right?
Both public and private.
Mm-hmm. Okay, I mean it's not worthy. I mean, perhaps private is debatable, yes, because of that challenge. But I know with public it would be very, very possible. It's something that I think we should put in place. We'll put together some proposals for that.
All right. Yes. Thank you, Francis. There was Njagi, who is not here with us, and Brandon. They've gone. All right. I saw Jeremani asking what will be the follow-through action points arising from this webinar. We shall collate all the views we received so far and the proposals and questions and do a write-up for presentation as our contribution, yours contribution rather, to this bill, and share the same with you guys.
Okay, so I don't know, for the panelists, perhaps any parting remarks, just a minute each. We'll start with you, Maria.
Yeah, thanks. Thanks for this, Liz. The panelists, Lawyers Hub, just a big thank you for hosting this forum. I think this is a very good way of handling any legislation that comes forth going forward, so that we're not stuck in court once a bill becomes an act of parliament and is set to be implemented. I would like to see more of this type of discussions with sector players and stakeholders happening, and a lot more informing the policy before any bill becomes law. So let's keep pushing. I think we still have to be very vigilant about the kinds of protections that need to actually get involved in this bill, and we'll still need to involve the participants and any other members of the public who will be, of course, notified when it comes to when the bill is introduced before Parliament. It is my hope that it will be sufficiently circulated, but if we are still operating under the same conditions that COVID-19 has placed us in, it will require that we are more vigilant and react quickly so that we ensure the right law gets passed. But thank you very much to you all for tuning in and for involving us as panelists.
Carol, last sentiments?
Thank you very much, Lawyers Hub, and for all the panelists who've been on this call. I'm really excited to see a lot of other IP practitioners who are in the comment section and also answering questions with regards to IP that some of the participants are having. I'm hoping that, the next time we have this conversation, it'll be, a more technical conversation in terms of some of the things that need to be revised within the bill. And I'm, hopeful that with all of us putting, our hats in the same area, we will be able to come up with a better bill than is presented to us at the moment.
Thank you. Over to you, Bernard.
Bernard, your mic is off.
Sorry, thank you. Thank you very much. What I'd like to mention is that there's a lot of power in unity. And I'd like to encourage everyone, belong to an association that covers your sector. If there isn't any, create one. When it comes to lobbying and lobbying the government for change, the government seems to listen more to organized organizations as opposed to individuals. So I would say if it's the animators, I've seen that there's an animators association. Any other sector, create an association, join hands and lobby for the right laws to be in place. Thank you.
Thank you. Over to you, Nonini.
Once, I'd like to say thank you to my very learned friends, advocates, and everybody who joined this webinar. And thank you for inviting me. Just like Bernard has stressed, it's very important to be part of an association. That's the only way you can have relevant talks with government. And we here as Creative Society of Kenya, as the chairman of Creative Society of Kenya, I'm inviting anyone who falls under the creative sector, be it arts, be it gaming, be it craft, design, fashion, to come and join us through your association, because we are an umbrella body and we can have deliberations with government moving forward. Asanteni sana.
Thank you so much. So over to you, David.
Last but not certainly not least. I think one thing that hasn't been discussed, I think it's been raised by a few of the participants here, is the issue about deadlines and urgency around this bill. What are the deadlines for submissions, and when is it looking like they might try and start passing this bill? Is there a deadline? We mentioned the whole bilateral trade influence, so to speak. That'll be just something I'd like to hear in summary. As a former auditor myself, I'm also interested, and again, I've picked up from some of the participants, the issue around digital taxation. It'd be interesting to see, and I know that's an ongoing conversation in government, but it'd be interesting to see how KRA and this bill, sort of talk to each other, so to speak. End of report. Thank you for having me.
All right, Aluso.
All right, thank you all. So for me, I would just like to say that my concern with this bill is that we do not have a lot of emphasis on the technology space and the legal issues that surround the technology space in terms of contracts that you're getting into, remedies available to you who is involved in that space. So I would be looking forward to that issue being addressed in the technology world. I will give my proposals as well. And hopefully we can have a further engagement, as Carol said, a more technical conversation on how best to, put all our views together in contribution to the bill. I have seen that the bill is still open for views up until 17th of this month. So I guess we should hopefully meet again and do a further conversation if the need arises and the time allows. Thank you so much.
All right, so without further ado, we want to thank the panelists for making this discussion lively. I believe the attendees have learned something new. We thank you, the attendees, for taking your time to come and participate and hear what is going on. We encourage for all the attendees who are here to also feel free to share your comments on the bill. You can either share them to us directly as panelists. You can reach us out, to reach out to us on our social media, on our emails, and we'd be happy to also engage. And for any people in the ministries who are listening in, we want to say, we hope that you have been listening to us, and we are happy and ready to take care, to assist in this process. Kenya ni yetu, we are all for Kenya, and we hope that you will give us the opportunity to make Kenya great. So thank you very much, everyone. Please keep safe during this time. Stay at home if you can, and please wear the masks right. Please cover your nose. So thank you very much. Thank you, Lawyers Hub. And thank you, Aluso, for
Thank
sharing.
you too.
Thank you.